Hey everybody, this video is additional resource for us to be sure that you guys understand HIPAA and are aware of the severity of breaking HIPAA laws. You'll be required to watch it periodically in addition to your initial and yearly training on HIPAA with our company. So, we know you guys are wonderful people, caring, and great caregivers, but you need to understand HIPAA laws. So HIPAA is standard care. It is what's right. It's patient rights to have their medical information kept confidential, but you need to know it's also federal law. HIPAA is Health Insurance Portability and Accountability Act of 1996. It is federal law. So if you share healthcare information of one of your clients, whether it be intentional or even accidental, you are breaking federal law, and that can be consequential to our company and to you personally. There's two parts of HIPAA. That would be the privacy rule and the security rule. The privacy rule identifies what information is to be protected and outlines the individual's rights to control access to their healthcare information. The security rule defines how to protect protected health information in electronic form. The privacy rule states personal health care information must be safeguarded by organizations and the individuals who work there. Patients have rights to gain access to their medical records and restrict who sees their health information. Organizations must train their workforce on the privacy requirements. Organizations must appoint an individual to be responsible for seeing that privacy procedures are adopted and followed, and the privacy rule punishes individuals and organizations that fail to keep patient information confidential. So if you are sharing healthcare information, it's not just Annville Adult Daycare that's going to be punished. It will be you as well. So health information that should be protected is any individually identifiable health information, anything that relates to an individual's past, present, or future health care, or relates to health care services provided to the patient, or that relates to payment or care, anything created or received by covered entity or business associates in any form, paper or electronic or oral communication. Any individual identifiers of health information include their name, their address, their phone number, finger or voice prints, social security numbers, vehicle device serial numbers, health plan numbers, certificate license numbers, account numbers, names of relatives, names of employers, fax numbers, birth date, admission, discharge dates, photographic images, x-rays, medical record numbers, account number, email, IP address, web URL. I feel like you guys know not to share information, but I feel like where it's gonna catch you is because we are a small community and everyone knows everyone. But your relationship with these people is through healthcare. If you didn't already know them before you were their caregiver, then you cannot acknowledge that you know them outside of your work environment. So if you run into someone who is a client at the store you can't initiate a conversation because they may not want the public to know that they know you, and they know you through a healthcare situation. So if you just your relationship with them altogether is protected. If they come up to you and start conversation, you can talk to them, but you cannot bring up anything healthcare related. They can share anything they want to share, and you can go along with conversation with them, but you are not permitted to bring up anything about them. We may have brothers and sisters on the program, or like mothers and daughters, cousins, neighbors, and they're gonna pump you for information. You may be at an apartment and you may have someone in apartment 403 and then go straight to 402, and they may watch you. Person in 402 may watch you walk out the door of 403 and come to their apartment at 402, and they may ask you how John Doe is doing in 403, and you cannot even acknowledge where you've been. It's obvious that you've been there, but your only answer can be due to HIPAA. I cannot disclose who my clients are or where I provide care. If family members are asking you for information, it can only be shared with those that our clients have permitted to share information with, and you don't really know that's listed in their charts, and you don't have access to their charts. So anytime anyone's asking for information, you need to just direct them to management staff so we can determine whether or not that can be shared. So the only time healthcare information can legally be used or shared is when it's permitted by law, which is for treatment, for payment, for healthcare operations, for public interest and public benefit, and that would be like during this pandemic that we've been in, where someone was exposed to COVID. The health department was obligated to notify those who were exposed. That's the only conditions that it can be shared, that someone has an illness, is during public health concerns. And when it's, of course, when permission has been given by a patient. So a breach of the HIPAA laws, even accidental breaches can be, they need to be reported, and we have to attempt to retrieve information, and they can be punishable by law too, because it can be harmful to the client, and it's our responsibility to protect their information. So, even an accidental, not intentional sharing of their information would come back to us, because it's our responsibility to be careful and not share anything, not let anything slip. So if there's an accidental breach, you're required to report it to the management team, and we have to make an attempt to retrieve that information or limit the exposure or risk to the information being shared. Definitely report it immediately. And that would be, an example would be like if your job was faxing information to the doctor's offices here from the center or the office, and you accidentally faxed lab work to the phone company instead of the doctor's office, or if you called and left a message on somebody's personal voicemail instead of the doctor's office's voicemail, um, that would be an accidental breach of information. Also, with HIPAA, you're only allowed to know the minimum amount of information necessary to do your job. So you're only allowed to know what you need you're only allowed to access what you need to know in order to do your job. An example of that would be like if you see only one client, the client next door that someone else is seeing, you don't have any business knowing anything about them. Also, if you take care of this one client and you don't, they had diseases or operations years prior, that does not make any difference in the care that you are giving them today, then you don't need to know that. You only need to know what's pertinent to provide care to them today. So you shouldn't be discussing with other staff the clients that you take care of if it's not shared clients and it's not need to know information. Just gossiping about their day or things that they do during the day is not anything that you can legally be discussing between staff. You can never be talking about your day with your clients at home or in the community. Even if you don't tell their name, you can't be talking. You can't be taking pictures in their home, because even if the client is not in the picture, if someone recognizes wallpaper on their walls or the couch you're sitting on and recognizes where you're at, then you have accidentally broke HIPAA laws, because they know that you are providing care in the specific person's home. So you're only allowed to know the minimum amount of information that you need to know for treatment purposes, and that's it. So patient rights through HIPAA. Patients have the right to receive the notice of privacy practices. They have the right to access any of their information. They have the right to an accounting of any disclosures. They have the right to restrict the use of their health information. They have the right to confidential communications. They have the right to request an amendment, and they have the right to file a complaint. Disclosures have to be kept on file for 6 years. Clients have the right to have a copy of that at any time. Examples of possible breaches of information would be if you have any paperwork with any of their information. And remember, that's not just their name or health care medical records. That's anything with their birthday, their phone numbers, any of their information on it. If you were to throw that in the trash somewhere instead of having it shredded, that is a possible breach of their information. If you share their information with those who don't have the need to know, that's a breach. Posting it on Facebook would definitely be a breach, and that would just be on social media, you can't even, because you now know these people through your job. You can't send like friend requests or whatever on Facebook or Instagram or Twitter or any of those social media sites because you only know them through your healthcare position. If they send you requests, you are allowed to accept if you choose to by law, but you cannot comment, you can't send messages, none of that. If they comment, you can reply. If they send you a message, you can answer them, but you can't initiate anything with your clients. So keep in mind, if it's their birthday and you know that, and you say happy birthday on their Facebook, then you have possibly breached HIPAA because you are announcing their birthday. And you may or may not only know that because you have access to their healthcare information. So it's very, very important that you're very, very careful with these people. I know you're all very caring, compassionate, loving people. You have to be to do this job, and we spend a lot of time with these clients, and you get to feel like they are friends and family, but you have to keep in your mind that our clients are not our friends and family. We love them, but we work for them, and they will try to get information from you on their neighbors and their family members. And it's difficult to hold that in when you spend so much time with them. But please know that if you share any information with them, they will not be afraid to let us know that you're talking about other clients to them. And they will know that you can be persuaded to share information on them. And that does not make our clients happy at all. And it's illegal. So, another more examples would be, faxing a document to the wrong fax number, or if something gets lost or stolen. If your example of that would be if you leave like your clipboard in the car and your car gets broke into, and that's what they steal, and it had your sign in and out sheets with their names on it, and that gets stolen. Even though you had no intentions of anybody taking that, it would be seen as, that was not a safe place to leave their information. And by law, in court, they would look at that as that you should have known not to leave their information in a vehicle. It should be kept somewhere safer than that when you're not directly with it in that vehicle. So when there's any level of a breach, you definitely have to report it to your supervisor as soon as it occurs or is discovered. And then an investigation is started. Some penalties for non-compliance with the HIPAA rules would be civil money penalties if there's a violation but you did not know or you could not have known that it was going to be, the information was going to leak out. You can still have a $100 per violation with an annual maximum of $25,000 for repeat violations. For a violation due to reasonable cause and not due to willful neglect would be $1,000 per violation with an annual maximum of $100,000 for repeat violations. Violation due to willful neglect but corrected, $10,000 per violation with annual maximum of $250,000 per repeat violation. Violation due to willful neglect and not corrected, $50,000 per violation with annual maximum of $1.5 million. And that's punishment by law for you, not Annville Adult Daycare. That's you personally. Criminal penalties, that's if you knowingly commit the offense, up to $50,000 and 1 year in prison. If it's committed under false pretenses, $100,000 and up to 5 years in prison. Committed for financial gain or malicious harm, $250,000 and up to 10 years in prison. So, the HIPAA laws are very serious. General safeguards for protecting healthcare information. You guys just need to always remember to protect the privacy of our clients and the security of their information when you talk about it, when you fax it, when you store it, when you use it, when you disclose it, and when you dispose of it. So what if a breach occurs? Don't try to hide it and pretend like it didn't happen, because you don't want to get in trouble. If it's accidental, it still needs to be reported. Report incidents to your supervisor immediately. We have to investigate. So the security rule, which is, the protection of the information in electronic form, you just need to make sure that you're always logging in and logging out of Teams and EVV as you should. Don't give anyone else your passwords, your login info. And it says that we have to keep documentation for 6 years. Tips for HIPAA compliance: log on and off of networks appropriately. Never let others use your ID or work under your ID. Do not disable antivirus software or install unapproved software. Never introduce new hardware or media. Email may not always be secure form of data transmission. Do not email health information unless using encrypted means. Use caution in opening email files from unknown sources. Do not access non-permitted information or give non-permitted information to unauthorized employees. Be aware of and report security threats to the security officer. If you're printing information, get it off the printer as soon as possible, because just other staff or other clients doesn't need to see it. If you're not certain about somebody's health information, if you should be sharing or if you're allowed to share or what you're allowed to do, check with supervisors, management staff before you do anything. Ask for additional training if you feel like you need it. If you have any questions, ask. So that's all really that I have to say. I think you guys all do a wonderful job with our clients, and they love you, and we love you too. But if you have any questions, just let me know, and keep in mind that everything has to be kept private for our clients. It is their rights, and it is federal law, and you can be severely punished if you're sharing their information without their permission. Thank you.